Okay, this is going to be my general summary overview of the motion for judgment on the pleadings. Little girl attorney and I are going to go live at 10:30 Pacific, 1:30 Eastern, figure it out in between. And she did a summary last night. I'm going to refer you back to a couple of my videos that I've done on the issues that are being brought up here. So if you want to do that homework, you can. And then we will go live and you can ask whatever questions you might have as we figure all this out, including not only the legal arguments, but why this is happening. So I want to start off by going back to this diagram, which I have used in helping people understand the summary judgment issue. But when I teach civil litigation as a class, I write something like this on the board almost every single semester. And by the end of the semester, I expect the students to be able to write this themselves, because it's sometimes on the final exam, because this is sort of the trajectory of not only how civil litigation cases go, but it shows you what all of the off-ramps are for a defendant who wants the case to go away. So you may remember earlier, the complaint gets filed, and then you have the right to file either an answer or a motion to dismiss. For whatever reason, Wayfarer chose to file answers instead of a motion to dismiss or motions to dismiss at that time. We don't know exactly why that is, but I think it's probably fair to assume that if they had gotten the case dismissed at this stage, it would have allowed the lively people to say, we never got to see the actual evidence because they got the case dismissed before discovery, and it would have allowed that narrative to continue ad infinitum. Now, what we've been expecting and waiting for is a motion for summary judgment. And a motion for summary judgment is where you make legal arguments that the case shouldn't go any further, but you get to consider everything that's been gathered in discovery. So remember in this continuum that wherever you see a motion, what the court can consider in deciding that motion is only the things that come before it, above it, on this continuum. So when a court is looking at a motion to dismiss, it can only consider the complaint. When a court is deciding a motion for summary judgment, it can consider everything found in discovery and the complaint and the answer, right? So the weird one is what we're dealing with now, which is a motion for judgment on the pleadings. I am a big fan of it. It's not used all that often, but I think it can be a really useful tool, and I think that's what we're seeing here. So technically, a motion for judgment on the pleadings is a lot like a motion to dismiss, in that you don't consider anything in discovery, because look, that comes after. And you're basically making legal arguments that even if the plaintiff proves everything that's in their complaint, even if their allegations all turn out to be proven by facts, legally speaking, they still cannot prevail, because the law does not allow people to prevail for those claims on those facts. The only real difference with a motion for judgment on the pleadings than a motion to dismiss is that a motion for judgment on the pleadings, number one, can be filed anytime. And number two, the judge can consider both the complaint and the answer if they need to. So what's happening here is that Wayfarer is saying, we're going to make the arguments we could have made at the motion to dismiss stage but didn't. And we're going to make them before we get to the point where motions for summary judgment are due. So why are they doing this? Well, first and foremost, I think they might actually win a couple of these. Sometimes you file a motion because you think you can win it. I think that if they were able to prevail on some of these at this stage, it would allow Wayfarer from a PR standpoint to say, these claims were always legally problematic. They were never going to get all the way to trial because she was twisting the law in a way that the law doesn't allow. But rather than make that argument up front, what we did was we said, okay, let's do discovery. Let's talk to everybody. Let's let all the facts out there so that they can never come back and say, we'll never know what really happened. So I think that's a possible strategy on their part. But I think there's probably more to it than that. I think, as Little Girl Attorney said, they are also making a record of these legal arguments for the appeal, if there ever has to be one, right? This is what you make an appellate record for, is legal issues, because appeals courts decide legal issues, not fact issues. I think they are previewing some of their summary judgment arguments. If some of these don't get granted, A lot of you have been asking, can they bring them up again in summary judgment? Yes, they can. And the reason is because the arguments are different. Here they're just saying you don't even have to consider any of the evidence. The way they're pled makes them legally insufficient. At summary judgment, they would be making the same argument, but including all the information they found in discovery to say, now we've seen the proof, and it still isn't enough. So yes, they could raise these issues again. When you get to summary judgment, that's a little bit harder to do because there are facts involved, and it's easier for the person who is opposing summary judgment, who in this case would be Lively, to say, well, but there's this one piece of paper, so we might have a legal issue here, right? So it's a little bit murkier there. So I think what they're doing is they're trying to say, is there any way we can just get out of some of these legally speaking and not have to deal with, by the way, hundreds of thousands of dollars worth of summary judgment motion practice, and be able to say, here's all the information that was out there, but it didn't matter because the court found that the law doesn't allow recovery for this, but all the information is now out there and the public can do with it what they will. I think everybody gets tired of litigating. I think it's worth a shot. I think that in this particular case, Wayfair has seen, based on what happened to their case, that this judge is very much willing to dismiss complaints and claims if he thinks that they don't have any legal merit. You know, you never really know when you go in front of a judge unless you've been in front of them multiple times. Is this person actually going to pull the trigger and say, you know what, we're not going to go any further? State court judges tend to be real sketchy about that because they don't want to get overruled and they have to worry about staying in their jobs. But federal court appointments are for life. And so federal court judges are a lot more likely to be like, you know what, maybe this is not what everybody else would do, but I'm saying no. And we have seen that Lyman was willing to do that in this case. So I think they're betting on that as well. Also, because everything that happens in the litigation this is also putting a pressure point on Lively. This is putting a pressure point on her to say, what if all of your claims suddenly go away? What if some of your claims suddenly go away? Then what are you going to do? Whether it's pressure for settlement, whether it's pressure for something else they're trying to get for her, filing a big dispositive motion like this is a big piece of leverage for the Wayfarer parties for whatever they might be negotiating or talking to the Lively parties about. And if you're wondering, this is the rule. Actually, hold on. So Rule 12 of the Federal Rules of Civil Procedure is the rule for defenses, and it's where motions to dismiss come in. They're called 12b6 motions, right? And it's talking about how you present as a defendant what your defenses are. And the first part of it is all about motions to dismiss. But when you get down to 12c, it very briefly mentions motions for judgment on the pleadings. After the pleadings are closed, that means both complaint and answer have been filed. But you can't do it like on the eve of trial, right? You can move for judgment on the pleadings. Now, one of the things that Lively could do is try to argue this isn't really a motion for judgment on the pleadings, it's a motion for summary judgment, and we have to treat it as such because, you know, whatever. She's going to make some argument that they're muddying the waters, and they're saying that it's only about the allegations and the complaint, but really they're bringing in facts. But I haven't seen them do that. They haven't raised any deposition testimony, any records, any documents, any emails, nothing. All they are citing is, even if, remember that, one of the things I suggest you do if you want to do homework is go into my Lively Baldoni FAQ, or is it TikTok Law School? I can't remember where I put it. I don't know. It's in one of the two, and it's a video on affirmative defenses where I talk about how affirmative defenses work. And they are yes, but arguments. That's also what a motion to dismiss is, and that's also what a motion for judgment on the pleadings is. Even if the plaintiff can prove every single allegation of their complaint, even if we assume they're going to have a totally clean set of proof for all of that, legally speaking, they still cannot win. That's what this motion is. So that's the big picture. I'm now going to do part two. Part two is going to be on the arguments themselves.